course, we have Rick and Lisa, our star players, all stars in the real estate industry. So they are gonna, our CPA couldn't make it last minute. The attorney might be lost. So we're gonna have the two of
It's okay, we
them.
have Rick.
And I almost got clipped on the freeway. I kid you not. Guy came out on the far right, right in front of me. I still have adrenaline going. All right, so that's the way we're starting out here today. But now Rick is going to cover some of the attorney side because he's done hundreds of these probates. So let's start out with Rick. Can you please explain, let's say the grandparents have a home of 50 years, they pass away, and they do not have a trust in place. Conversely, across the street, those grandparents passed away and they did not have a trust in place. Or they did. Okay,
So basically, if the property's in a trust, you guys hear me okay? If the property's in the trust, you're going to avoid probate. The reasons you want to avoid probate is it's very expensive and time consuming. Some probates I've been involved with have taken, years as in plural. Okay, just so you know, they can be. And the attorneys are paid on a scale based on what the estate is worth. So you spend $3,000 or $4,000 to get a quality trust. If you're in probate, it's going to cost you $3,000 or $4,000 to call the attorney the first time you talk to them. Okay, after that, you're going to be on a scale that is set. So it's extremely expensive, and the more value that the estate has, the higher the probate fees. I have seen cases where probate fees have exceeded $100,000. Now that would be more than a $3,000 or $4,000 or $5,000 trust document. So that's the basic difference between having a trust and a probate. And that's the basic difference. Probates get a little bit more squirrely as we get into them, depending on the will and whether there's a dispute and whether there are named heirs and or administrators or executors, etc. So you really go down a rabbit hole. With a trust document, the trust basically lays everything out. There is a trustee or multiple trustees, as Lisa knows. How much fun is it when there are more than one trustee, Lisa?
It's fun.
Yeah, she means not. Okay, because sometimes they don't agree. But basically in a trust, everything's laid out. Trusts are many pages. A will is typically a few pages. So a trust, basically, the attorney crafts that with the grandparents, and the grandparents decide where everything goes. Well, first of all, they tell them where everything is. And hopefully, if they're doing everything right, they title everything in the trust. And then after they pass away, the trustee is the person that administers the trust. That's the person that runs the show. Okay. They're the ones that have access to the bank accounts and the stock, and they can sign for the sales of things such as property. They're the ones that administer it on behalf of the beneficiaries. And in this case, grandparents had lots of children and several grandchildren. So those could be named beneficiaries. They can name whoever they want. They can give them whatever they want in whatever percentage they want. But the difference is that it's in a nice, neat document that the trustee is charged to administer.
okay. Lisa,
Yes.
what should realtors verify with the escrow officer before they even list a probate or trust?
They should always let us know how.
Here's the question, Pat. I'm sorry. Oh,
Did not? What should
Test.
what should realtors verify with the escrow officers before they even list a probate sale or trust sale?
We always want to know how the homeowner holds title for the home. This will decide if we're going to be going through probate or a trust. So we already know the homeowner is deceased. So we need to make sure we know how they hold title. If it's in a trust, then we're going to ask for the trust. If they do not hold title in a trust, or there's not a surviving joint tenant, then we're going to need to go through probate.
Okay, Rick, what's the first thing a Realtor should verify before even discussing a listing a probate or a trust property?
Let's go with the probate first, because that's a bit more complicated, okay? During a probate, we're going to assume there's a will. If there's a will, there's going to be an attorney involved, and that attorney needs to go to the probate court and have the court confirm the executor who is named in the will. Once that happens, the judge will issue what are called letters of testamentary, and they will appoint and confirm that particular individual as the executor. That's all well and good. You can take it right into the recorder's office and get it recorded at the same time. Once you have certified copy of the letters of testamentary, then you can take them to Lisa, and Lisa says, oh, good. Now we know that it's legal to do some things here. If there is no will, then we have a bigger problem, because now the attorney is working with somebody that we hope is related to the decedents, the people that died. And they have to go to court with various different documentation and get an administrator appointed, which is usually a family member of some sort. It could even be a friend. Once that happens, the same course is taken. The judge confirms it. Letters of testamentary are issued. They're then recorded in the county recorder's office. Now you have a legal document and a court order saying, yes, this person can act on behalf of the estate.
Okay, we're still in the first section here, the escrow perspective on probates before listing the home for sale. Okay. Now, Lisa, so we might cover the same turf,
Yeah.
but from different angles here, right? What documentation do you need from realtors at the very beginning that's different from a traditional sale?
Well, we definitely need the attorney information, so we can go to the attorney to request the petition for probate, the order for probate, and the letters that Rick was explaining. So once we and a will, if there's a will. So once we have all that, we submit it and we start the process for what we're going to need to insure the property.
Okay, Rick, this is one of my favorites. There's an adult child living at home and 3 or 4 across the United States. How should realtors handle situations where multiple heirs have conflicting opinions about selling the home or how to sell it?
This is why they pay me a lot of money. Okay? I'm dead serious, because if you're going to engage in this type of transaction, your ability to deal with those people in a kind and considerate fashion, and yet telling them the truth and making things work, is a burden off of the attorney. It's also a burden that has been taken away from the trustee. The attorneys have no problem with it, by the way. They can deal with it all the time. They do deal with it all the time. They're a little bit more direct. All right. So you do end up needing almost everybody to get on the same page, because it makes life a lot easier. In a trust, the trustee calls the shots. If the trustee says, we're selling the property and we're going to divide the assets, that's probably what's going to happen. Now, that doesn't mean that the beneficiaries who may not agree can't legally intervene in some way, shape, or form. And that happens, I would say, 20 to 30% of the time. And so behind the scenes now, I've got attorneys for 2 or 3 or 4 parties, and we're working together trying to figure this out. I'm providing data on the values, either repaired and improved or as is, etc. They typically want to know what's going on tax-wise. Some of them think, well, we're going to move into mom's house and just buy the rest of you guys out. That is an exceptionally difficult proposition to do, okay? Because usually they have no money. In addition, even if they had the money, Prop 19 now makes it nowhere near as advantageous. If you are living in mom's house and mom dies and it's worth $2.5 million, the first $1 million of assessed value stays the same. The next $1.5 million is taxed, property tax wise, at market rate. All of a sudden, you don't get to have mom and dad's $1,345 annual tax bill. Okay, it doesn't work that way any longer. So you have to be able to deal with the attorneys. Now you're dealing with more than the one, and all of the heirs, and you don't necessarily talk with the heirs directly. Oftentimes you're talking through the attorneys. So there's a lot of things going on. So your communication has to be accurate, and you can tell the attorney anything, you can give them a hard time, and they're oftentimes the ones that are going to take it to the heirs. Bring it to the heirs, that would be better. Yeah. And that's how you get your response. It's just commonplace. Like I said, 20 or 30% of the time. Some years it's like every transaction I did was a war. But that's just the way it goes in these things.
Okay, I forgot to thank our MLS because this section is about before you list a property on the MLS, right? Okay, hang on, Lisa. I want to remind everyone that our MLS has all these reports, cities, zip codes, counties that are helpful for trustees and probate administrators, as well as, we got to thank Jody because Gov Hutchinson says she's the best in the state of California. Okay, so, okay, Lisa, preliminary title. So they haven't listed it on the MLS yet. What preliminary title issues commonly appear in probate and trust sales that might be problematic?
Well, when you list a home, we need to get that prelim going right away so we can see what's going on the preliminary title report. That's the most important thing for my job to make sure everything goes smoothly for you guys. So one of the most important things that we're looking for is what needs to be on the prelim in regards to loans. Is the property free and clear? Sometimes when a loan is paid off 30 years ago, it's never been released. And that's a lot of work to do to get that cleaned up. So it takes time. So that's why you're going to call me right away. Let me know what we're dealing with, get that prelim opened, and then we go through it and see what needs to be done. So if there's an old loan on it, we hop on it, as Rick knows. Sometimes we have to get a bond because a lot of lenders are long gone, but we do our research. We just need time.
Those old seller carrybacks, the 80s, when they had those money.
And back in the day when a loan was paid off, the lenders would send the original release to the homeowner. And sometimes we get those. Sometimes clients are really good record keepers. We love those. You never know. We have people coming into our office with a box of documents and we'll go through it. Whatever we need to do to try to see if there's an original release in there. It's called a reconveyance. But that's what we see the most on preliminary title reports is old loans.
Okay, Rick. So as realtors, we all will get the call, or we've had the call saying, my parents died, my grandparents died, I need to sell it. Can you come over here and sign the paperwork, right? So how do you determine, oftentimes, actually, they don't have the authority to sell it, right? So how do you determine? Yes,
Yeah.
your question here.
Actually, that's an easy part of what's going on, okay? Because in a trust and a probate, there's going to be one common thing, and that is there's going to be an attorney involved. So if it's a trust, then it's going to state specifically in the trust who is the trustee. Before they're going to believe who I tell them the trustee is, they're going to want a copy of the trust. And they're going to want it from the attorney too. They're going to want to talk to the attorney and say, all right, what's going on? So that's fine, because trusts are not recorded documents. They're notarized, but they're not publicly recorded. As far as a probate goes, that's easier because that is a document issued by the court that is recorded. And when Lisa gets that, she knows what's going on. One thing about those loans she was talking about, I have had that come up dozens of times, probably 50 or 60 times. And of course, you can't close unless they want to pay them off, right? And who do they even pay off? We don't know anything about the loan. Out of every single time that has happened, we have had to buy a bond one time. It's because Lisa and her crew at Chicago Title, and I mean right up through their legal department, because I've dealt with them more than a few times. These people are on top of it. I mean, I can't believe some of the lenders that they find and say, no, we got it taken care of. It's been reconveyed. We're good to close. It always blows my mind because up until that point, that's why Kevin and I have no hair, because we worry about these things, right, KB?
And we do too. We worry about these loans because we want to close.
We're going to hold questions, can we? Till we run out. When should a Realtor insist that their client consult with an attorney before listing, Rick?
If it's a trust or a probate, they're consulting with an attorney before I'm listing the property, period, end of story. They have to have an attorney. Some people say, no, they don't have to have an attorney in a trust. Well, that's legally true, but the ones I've been involved, let me give you an example. I've handled trusts for my family, both sides, my wife's family and my family, when everybody's passed away. And I did not do anything until we retained counsel. Yes, it cost money, but it is the smartest insurance that the estate will ever have. You have somebody else giving you legal advice so you don't do dumb things and you don't let other people in the family. Well, you know, I talked to an attorney and I'm the heir and this guy, well, he wasn't an attorney, but he was, I Googled it and look, you need somebody local. You need an attorney who understands what's going on, and you hopefully won't need them to litigate anything. But with an attorney, your career as a real estate broker or agent is a lot safer.
Okay, so we're going to hold questions till the end and fill in the gaps, any spots that you're not familiar with. Now we go to section 2, before accepting and ratifying an offer. Okay, now we'll start with Rick. What do realtors need to understand about the offer review and acceptance process in probate court sales versus successor trustee sales?
In a probate, generally speaking, the administrator or executor is either going to have full authority under the Independent Administration of Estates Act, which means they can sell the property, or they're going to have partial authority, which means they have to go to court to confirm the sale. You do not want to go to court to confirm the sale if you can avoid it. That limits the number of buyers. It becomes problematic. It delays things significantly because you're not going to get into court the next day. It's a good 30 days out. So that's one thing, all right? If you have to do a notice of proposed action, we refer to that as an NPA. In other words, there's beneficiaries and they have to basically get their say. So when you sell a property in probate, oftentimes you might have a 15-day contingency based on the notice of proposed action being sent to the beneficiaries. And that basically says this: we listed it for this much. We were hoping to get an offer in this range here. The offer we have is in this range. This is fine. We intend to accept this. Please tell us if this is okay. The reason it's a 15-day notice is if they do not respond, which is very typical, then it's concluded by the court that they have approved the sale. So the worst it could take is 15 days. Because they almost always, and here's why they approve it, unless it's really out to lunch. What do they want? They want their money. In a trust, it's a different story. If everybody's on board, not a problem. But when you get an offer in either circumstance, you alert the attorney and you let them know what's going on. Most of my attorneys I've worked with, for some of them I've worked with over 25 years. They don't necessarily need to see the offer. I'll send them a summary, say, here's what's going on. This is where we're at. This is what I think we want to do. They're usually on board 100% of the time. But they need to be at least told what's going on before their client signs a document that they're going to have to back up. So you tell the attorney when you get the offer, you give them at least a summary. If you've never worked with the attorney before, you send them the offer and you go over it with the attorney, and then you go over it with your clients or all of them at the same time. However, the problem with trusts, and this is rare, but it does happen, trusts have a notice of proposed action time frame of 45 days. How many of you would like to represent a seller and tell the buyer, say, hey, we're all good to go. We have a 45-day contingency on the seller's side. How many of you think that's going to work out? Not so much. So when we know there's going to be a headache in advance, before the property even goes on the market, I sit down with the attorney and we craft a general NPA, which says, This is how we determine what the value of the property is. This is what we're gonna list it at. We're gonna consider accepting any offers in this range. We're gonna spend this much money on the house to put it in good condition and do all these things, and then we send it to everybody. Same thing. I've had trusts with as many as 16 beneficiaries. By the way, both of those properties sold like this, boom, smooth as glass. It's the ones where there's a brother and a sister. Yeah, not so good. The point is that if you're on top of things and the attorney trusts you and knows what they're doing, you can send out the NPA basically before you even put the property on the market, as long as you have a listing agreement to the effect of the asking price that's valid. So that's a way to avoid those kind of things. It's not necessary in all circumstances. But if the attorney sits down with you and says, we're going to have issues with these heirs, that's when you make sure that takes place.
Okay, Lisa,
Yes.
might cover this again here, but what are common mistakes do realtors make when opening escrow on a probate or trust sale?
Not letting us know that this owner is deceased. That's kind of important for us.
That happens a lot.
Yeah, it does happen a lot.
You'd be shocked.
And then we get going and it's like, oh, by the way, and then they put it on the market. Oh, we're going to take offers. No, because we want to close it for you. So the way to close it is to let us know.
Let me, okay, want to hold your questions?
Did I hear that correctly?
Mm-mm.
No.
An
Okay,
entity sale, a trust is an entity sale, but so is a corporation or an LLC. And you'll notice on the signature pages on the listing agreement and the RPA, all the RPAs, there is a box for entity sales. If you use that box, then ostensibly you don't need to do the RCSD, which is Residential Signature Disclosure Advisory. Okay, so.
okay. So let's hold our questions to the end. We're going to have extra time. All right. You want to sit up closer? Come up closer. Let's come over here.
Sit under a speaker. Where are they?
Thanks, Pat.
You're welcome. Okay, speaking of deceased sellers, how about incapacitated sellers? Let's just jump to that. No one mentions that to you. Or they come in and grandfather has a walker and he doesn't know where he is.
Well, we can't sign them. That's for sure. Usually we know ahead of time if somebody's incapacitated. So within the trust, it talks about that situation. So for escrow, if we know they're incapacitated, that we want to resign them from trustee and appoint the successor trustee as the new trustee. And we require two doctor letters to confirm that the trustee is in fact incapacitated. So once we have those, we review them, we can do a change of trustee. The successor trustee can then sign. So that's why it's so important to have a trust.
Okay,
Right.
Rick,
When she's talking about that, she's making an assumption, which is usually accurate, like 98% of the time, that in the trust, the trustors, the people that own the property, grandma and grandpa, they designate the trustee. Okay, this is the person who's going to handle things after my passing. They also designate, at least 99% of the good attorneys will recommend they designate a successor trustee beyond that. Okay, because if mom and dad don't know when they're going to die, mom and dad don't, sometimes, sadly, children predecease the parents. So typically a good course of action, and good attorneys will recommend this, you put in writing in your trust, if John Doe is not able to serve as trustee for any reason, and it's legal reasons are then, it's cut and dried, it states incapacitation is one of them, death is another, then Jane Doe will then become trustee. So then all you have to do then is, we've got a document that's already been notarized. We look at this, we get Jane Doe to come in and say, hey, do you want to be the trustee because you're named next? And is there anything legal you'll need to move forward once that happens? Is there?
Right.
Tell us about that.
We just need to review the trust to make sure that Jane Doe can sign on behalf of the trust. And if she does not want to sign, she can resign. And then the next person will be designated.
Now, if you run out of designees, you got a problem.
Yeah, we have a problem.
The house will not be sold anytime soon, okay? Because now it's between attorneys and any heirs or beneficiaries. And if that happens, you're probably going to see a few more than might have been listed. You know, we
Okay.
have war stories for later.
Rick, let's just touch on my favorite contingencies. I love contingencies. I think they protect everybody. What contingencies are typical or problematic in a probate or trust sale?
Well, let's face it, for the last many years, we've been in a pretty heavily seller's market, and non-contingent offers are typically the norm. Most of the properties we're getting non-contingent offers, but, and that's okay. But if you're representing the seller, the only contingencies that you're really concerned about are ones that you're going to have trouble as representing the seller getting together. And those would be, are the heirs going to agree? That's where the notice of notice of proposed action comes in. Again, 45 days on a trust, 15 days on a probate. So, and the way you either avoid that or minimize the headaches with it is by having conversations with the beneficiaries, or having someone have conversations with them, maybe the executor or administrator if there's no will, or the trustee. Find out, are we going to have a headache here? Is there going to be a problem? You know, and again, that's how you handle it. It's done in writing. And once all those documents either come back or the attorney states the time has passed, we have deemed approval, then you can go forward. But that's the main contingency that is a headache with probates and trusts.
Okay. Let's talk about earnest money deposits. I'm going to skip ahead here, Lisa. I'm not sure if we had that question for you. Oh, yeah, we did.
You do.
Okay.
It really doesn't affect earnest money deposits unless the public guardian is involved. So the public guardian's office, they do a lot of trust and probate sales. They step in when family is in need of that. So for them, they want the deposits ahead of time. So what happens is that instead of the money going through escrow, the money goes directly to the public guardian's office. But other than that, it's business as usual. We'll take the deposit in.
Now, is that often a bigger deposit?
I think it might be 10%.
10%? Yeah. Okay.
From time to time, you'll run across a probate attorney who believes that he needs a 10%, or he or she needs a 10% deposit also. But it's rare, it's not required. The law doesn't require that. Guardianship is a different story.
Okay. Lisa, how should realtors explain the escrow timeline differences to their home buyers and home sellers?
So for the probate, like Rick was saying, we can close within 15 days from the date of the notice of proposed action, as long as there are no objections and all the paperwork is in order. Sometimes court orders can have a 120 appeal period. But for example, that's if there's an heir who's appealing the transaction. So basically, we just review everything, make sure we know what we're dealing with, and then we'll confirm what the timeline will be when we have all the facts.
Rick, can you talk about that? When the county's involved, I did that once years ago. We go down to the lobby and the sheriff brings up the top floor and there's a long conference table and all the agents sit at the conference table. Their buyers are behind them. They put in a sealed envelope, slide it down to the end. Is that
Well, I
rare?
haven't had that one happen, but I've been to court confirmations in more than one county. You know, and court confirmations, basically you go to court to confirm the sale. And by the time you're in court, the buyer is basically ready to close escrow. All right. They're aware that it's a court confirmed sale. So then if there is the judge will say, are there any bids on this transaction? And they will give you the minimum opening bid, which is 5% plus $500 above the actual asking price. So it's a jump, you know, on $1 million transaction, that's $50,500 above, you know, the $1 million price. So you don't always get that to happen. I have seen it happen. I've represented sellers and buyers in those circumstances. And then the judge can, once that's set in stone, once the initial bid has been proffered, the judge can then determine for themselves what the increments will be. Sometimes it's 5,000, sometimes 2,500, sometimes 10,000. It just depends. But the final decision rests with the judge. I have been at a court confirmation hearing where I was representing the buyer and the seller. By the way, don't do that. I was young and stupid.
Yeah.
But the buyer was an attorney. So we went to court to confirm the sale, and they had an overbid, and it wasn't an expensive property. And so I meekly raised my hand and asked to see the judge. So I got to go up and I said, Your Honor, this offer is a 30-day close filled with contingencies. If you accept this, we have no guarantee that it will sell, that it will close escrow. Here's my documentation from the title company indicating this buyer will record the deed tomorrow. So do what you want. I'm just saying that anyway, my client got the property and that ended that story. Because the judge doesn't want to switch, he doesn't want to do all this, he or she doesn't want to do it all again. You know, well, just because this guy says they're going to perform doesn't mean they're going to. These were the days when contingencies were rampant, okay? This was not this century, okay? I've been around for a long, long time. But that's what happens. Judges want finality. They want to make sure if they make a decision, boom, it's done. Let's move on. Next case. So that can happen.
Speaking of accepting offers, oftentimes we'll see listings and offer date on Monday, or let's say Wednesday at 5, and it's still on the market the following Monday. And you talk to the agent and say, yeah, we had 18 offers and it's still on the market. Now, the MLS, by the way, another extension 2 for compliance, you can call and complain. But how does that play out with the multiple listing service? When do you ratify or mark it as a pending sale?
As soon as the contract is ratified, it's a pending sale. I mean, worst case scenario, you mark it contingent with something that may indicate there are some contingencies with the transaction, not contingent upon the buyer selling their property. But I can't imagine a circumstance under which I wouldn't immediately change the status on the MLS after a contract is ratified.
Yeah, sometimes, let's say they have a successor trustee and the agent's collecting offers and then sends them back east to an adult son. And it's just sitting there. Have you come across any of those situations?
DocuSign, you can sign right away.
Right, so this is a listing agent problem. And that's why the MLS has a compliance. And I've done this. You can call, press number 2, tell them what's happening, and then boom, that property will be marked as a pending sale within an hour or 2.
No,
Okay.
listen, nobody wants to waste their time showing property that's already sold, correct? Or answering questions from your buyer, especially the ones that say, hey, we wanted to write an offer. What do you mean we can't? Those aren't questions that we should be dealing with. And it's the fault of the listing agent who doesn't change the status after a sale is ratified. Even if there are issues with the sale, it's a ratified transaction. We, the rest of the agent population, we need to know that. If it's got some contingencies that need to be dealt with, fine, you can mark it pending, continue to show with some contingencies, fine, but it's still a pending sale.
Okay. Rick, I have one more question for you. What about when there's the adult kids and you have co-successor trustees and they don't get along? Are you sending group emails? Are you doing them one-on-one? Is it different every time? You know, one's driving a boat, one might live there or
Yeah,
nearby.
yeah. Okay, the two worst scenarios in a trust transaction when you're representing the trust is if there are co-trustees that either don't agree or don't get along. That happens. If there's co-trustees, it happens at least 50% of the time. And the other scenario would be, what was the other half of the question there?
Email.
Well, yeah, how do you deal with them in person,
Oh,
by
okay.
phone,
So
individually, collectively?
Basically, this happens all the time, and it's very rare that I'll get them in the same room, almost never. Oftentimes they're represented by different counsel, so I'm dealing with two different attorneys, one for each trustee. So when I get ready to make some changes or do some things that require some signatures, I have already had conversations with the attorneys. They're the ones that are thinking clearly on this. They're the ones that are looking at the data and saying, yep, that makes sense. That's total go, right? So you come up with your analysis, you say, this is what's going on. Both of the attorneys say, yes, let's improve the property with this much money instead of selling it as is. Let's put it on the market for this price here. Let's go ahead and list it for this amount of time. And we're all in agreement. So once the attorneys are on board, then I talk with the trustees individually. Okay. That's usually how you get things going. If one of them is living in the property, it gets worse by about 50%. Okay. Because if
Mhm.
they're living in the property, they don't want to go.
Mm-mm.
They think mom should have left the property to them. They think they did all the work with mom before mom died, so they have a right to stay there. They don't have any money, so they can't move. Shall I go on? You're getting the gist, right?
We know it.
That's a problem.
Been there, done
Yeah.
that.
That's a problem, and that's when you get the attorneys involved and you get things squared away. And this is where, if the estate has some funds, the trustees could agree. Everybody has to agree to everything. Say, okay, let's move brother out and put him over here for 3 months. The trust will move him, the trust will pay, but that comes out of his side, right? They can do that. You can do anything you want within the framework of the trust, providing the parties agree. But those are the worst case scenarios. Co-trustees or one of the, and it doesn't even have to be a trustee who's living there. It could just be a beneficiary, not the trustee. That has resulted in many police actions that I've witnessed. I've had meetings at the property where they came to get personal property, and we had to have police on one side and police on the other side because you had to make sure that sister was not in the house when brother came in to get personal property, et cetera, et cetera. And by the way, those are the mild ones. It can be a lot
Yeah.
worse. But generally speaking, that's not how it goes. But when there's co-trustees, when you guys put together your trusts, do your kids a favor. Don't have co-trustees, okay? And the other thing is if one of the kids living in the property, that's one of the more difficult scenarios because sometimes they just don't have anywhere to go. And they have, well, he's been ill and he hasn't worked for a little while. How long? Well, he had a job in 2013. This is what I hear. It's like, and you go in the house and it's like, oh, I see. He also didn't remember how to empty the garbage because that's what he used the family room for. This is
Yeah.
not made up. This is what happens.
By the way, has anyone ever met in property management or in sales, you ever met an adult child that lives at home that was helpful? No. Okay, they often refer to it as my house, right? And so let's talk about the timelines. By the way, and for both of you, Lisa Knight at Chicago Title, is that right? Timelines, a probate, how long, what's the longest and shortest mid-range?
15 days for probate with a notice of proposed action. So once that's issued, the date on that notice, we can close 15 days after that date. Yeah, subject to nobody objecting or no news is good news. And then we confirm with the attorney after those 15 days that no objections have been done. We get a comfort letter and then we can close escrow. But we can also have 120 days depending on what kind of probate action it is. So every probate is different. And I can't really explain each scenario because, again, each one is different.
And Lisa is exactly right. But that's because when I bring her a transaction, we've already gone through the rest of it. Like
Yes.
we sold a duplex in Morgan Hill. Okay. It was You'll remember this one. Yeah, yeah. Nobody runs across this stuff except in these kinds of transaction. The owner of the property donated the property to the Crazy Horse Memorial Foundation of North Dakota. You cannot make this stuff up. Okay,
You guys should look it up.
when
It's
it went
really
into
interesting.
escrow, when it went into escrow, we closed reasonably smoothly. It might have extended a day or three, but it was basically a 35 or so day close. It was 4 years since the individual had passed away. And the attorney's fees were crazy because even though it was a probate, there was litigation. And even though it was probate, there was renters in the property. And one of them was a Section 8 tenant. And on and on and on it went from there. So it was, by the time Lisa got it, it was like, oh, this is great. Let's close. I said, yeah, we can do that.
We did get a bond. We had to get a bond.
Yeah,
That was the one.
That was the one we had to get the bond on, right? Because we couldn't, it was crazy. But working with good attorneys, and there were 3 on this one. There was also a trustee involved that was a corporate trustee, a rather large bank that you would all recognize the name of, that basically bungled the house for 3 years. Well, they were managing it. I said, guys, we have a septic problem here. And I noticed you spent about $20,000 in plumbing over the time you managed the property. They said, yeah. We put a bunch of new plumbing in there. But I said, but what did you do about the septic? It overflows every 2 weeks. Oh, well, we just pumped it every other month. Yeah, we had to replace the septic tanks and the leach lines before we could even put the property on the market. So sometimes things get strange, and until you get involved, you just don't know how strange they are. The key to these is having a good attorney that will take your direction. You know, when I got the vice president of this particular bank in San Francisco on the line and was able to grill him and ask some significant questions, because they gave us, I said, well, okay, just give us your P&L for the last 3 years you managed it. I got 3 pieces of paper. Neither one had more than half the page filled out. So that's when the call came in. So we had an understanding after that.
Rick, going to ask you some questions here that are not on your page. In terms of charges, for instance, adult kids that are locked up in their apartment, they're abusive, they won't come out. You know, I had a situation where the trustee, a longtime friend of the family, would fly in and I would meet the security guard, right, who's carrying a weapon. And then that's when we would have a meeting at the property. Now, those charges for that security, that would be built into, right? The trustee will be reimbursed for that.
It depends on the agreement between the parties. You got to remember, at that point in time, that transaction was being litigated one way or the other. It may not have actually made it to court, but attorneys were involved in both sides and negotiations were taking place as to who pays for what. More than likely, since the individual seemed to have caused the need, that would come out of their side. But again, that's where a good attorney can be worth their weight in gold, because I've had circumstances where we'll get to those eventually if we have time.
Yeah, we're going to have some time. Okay, keep writing notes. You'll have time for questions here. I just want to get back to the adult kids on this, how you two handle this. When, for instance, I had years ago referred to a gal who was selling her place, and we were at the kitchen table, and she's there in her probably late 60s, and the good-for-nothing adult daughter is sitting Indian style on the couch behind me, knitting or doing her busy work. And every time I asked a question of the senior citizen, the older adult, the daughter would answer. Right? So pretty soon I had to go back, okay, San Diego County, okay, where in San Diego County, right? Is this pretty soon I said, I have an idea. I moved my chair and said, why don't I ask you the question and your mother can answer? Right? So obviously I didn't get that listing, but now when you have people come into your office and the caregiver or adult child, or maybe the adult child that's not a successor trustee is kind of, who they say, whoever has their ear is driving the boat. How do you individually handle that? Is there an office policy?
Well, I need to make sure that the person I'm sitting with is competent. That's my number one goal. And if they're not, it stops right there.
Now, sometimes they might legally be competent, but they're getting bullied, for lack of a term, or
We usually know up front the situation before they come in. So I'm pretty confident in who I'm dealing with, the people in the transaction, the kids, caregivers, the trustees, the attorneys. We all need to know what's going on. But I'm not going to let anybody bully.
By the time they get to the signing table, we've typically mediated all of that stuff
Yes.
behind the scenes.
Yes.
And Lisa is then signing the person that actually is supposed to be signing the documents. And at that point in time, we've come to the conclusion that, yeah, they actually are competent, so we can actually do this.
I would hope you guys would know if your client is not competent.
okay, Rick, let's do both sides. You're a buyer's agent or a seller's agent. How do probate court confirmation hearings work, and what should realtors prepare their buyers for?
Well, if you're buying a property that's
Seller.
in probate, it's highly unlikely it's going to go to court for a confirmation. But if you're one of those lucky ones that's what's going to happen, you need to know the overbid process. And that's what it is. It's 5% of the purchase. Say, like I said, suppose you're going to confirm a sale of $1 million. It's 5% plus $500. Okay. So the first overbid has to be $1,050,500. Is someone going to show up and do that? You don't know until you get there. If you get there and you're going in to see the judge and they say, okay, all parties related to this particular matter stand up, and you see 20 or 30 people stand up, you got a problem. Okay, because and by the way, the buyer can also engage in the same overbid process. Okay, that happened to me in Solano County, and that was that. But that's what happens. Now, if you're the seller, you're kind of like, wait, somebody wants to pay more? All you're concerned about then is the when and if. Like, will it close and when? And the judge does take a role in that. So that's a different story. But that's how you prepare. If they show up, when you write an offer on a probate that requires court confirmation, just let your buyer know this could happen. It's rare. It's rare. Even, I mean, even I did one earlier this year where the fellow a young man passed away in an accident, and his only living heir was his daughter, who was 9, but his ex-wife, stepped in to help, and they were still on functional terms. We had to go to court to confirm her as the administrator of the estate. And initially they confirmed her with partial authority. And then I looked at the property, went through everything, went back to the attorney and said, hey, can we get full authority on this? Because that's how we're going to get the most money. He went back to court and got confirmation that we had full authority. That was on, it was in Hamilton Place.
Okay.
Whatever. And okay, got it, sold it. Everything went smooth from there.
We just walked in, court said you don't need confirmation, signed it off.
Again, the probate court, by the way, they rotate. There's no real specialist. They usually take a 2-year stint. They oftentimes will rely on the probate court attorney, and because he's the one that's there all the time. The current probate court attorney is Jonathan Kahn. He was in private practice for many years, and he became the probate court attorney, I think, in 2021. I've done a lot of business with Jonathan over the years when he was in private practice. By the way, it's helpful to know people like that.
Okay, so we want to hold your questions and comments to the end. You're going to have plenty of time here. Let's wrap it up. Third act here. Lisa, what's the most common reason probate or trust escrows fall apart that could have been prevented?
Well, because you're unable or unwilling to work with escrow on the documentation that we request. We have to remember that we are a title insurance company, so we want to insure the transaction, but we don't want to have any claims. So sometimes attorneys and real estate agents and sellers feel that we ask for too much documentation, as Rick knows. They need to understand where we're coming from in our process. So we ask for the information. I get it all. It's all funneled through me, but then I funnel it to underwriting. So underwriting, it's like a three-step program. That's what I call it. It goes to me, it goes to my title officer, and then it goes to underwriting. So I'm just kind of the middle person relaying the information. Okay, we like this. We don't like this. We want more. We start with what we ask for, and then from there, we're going to ask for more stuff. So we just need everyone to be patient and understanding.
And that's a serious issue. They're not going to insure something that they think they might have a chance of having to buy later, okay?
Yes.
We had one, I think it was Lori, it was several years ago, where the attorney that the attorney who's now long gone, of course, the attorney that drafted the initial trust put an incorrect legal description on each of the three properties that the parents owned. So, and each one daughter there was three daughters, each one got a property. So the first two daughters, they refinanced and kept the properties and everything was great, but mom and dad were alive and they took care of the issues there. Okay. When I got involved, mom and dad had passed away and now we're going to sell this property. And that's when, of course, they said, well, what do we do on the other ones? And we say, uh-oh, look, this is how we handled those. They were alive. It was about an 18-month gap between when we first wanted to put the property on the market to when we were actually able to legally sell the property. And there was a lot of going to court, and my clients were just beside themselves. They said, my gosh, I hope, I hope being off the market. Oh, by the way, I rented the property out for those 18 months. So they had an income. So they were able to pay the attorneys to take it to court. They were concerned because it was about $18,000 in attorney's fees over the year and a half or year and 3/4 that it was. We originally were listing the property at $895,000. And when we sold the property, we sold it for $1,250,000. So they were like, I had something to do with that. No, it was just that 18 months and the property went through the roof and we were lucky, but they were very thankful. And then they sold everything else and moved to a ranch in Montana. Seriously, they did that.
Rick, I spoke with you the other day about clients, successor trustees or whatnot that want the Realtor to answer all the questions, including legal questions and tax questions. How should Realtors coordinate with attorneys, CPAs, and escrow officers during the transaction, or how should your clients?
Basically, I'm there to answer real estate questions. Now, I've been doing this for so long that I have a reasonably decent knowledge of the legal issues associated with these transactions, but my license doesn't say I get to give legal advice, so I don't do that. So sometimes if it gets really in deep, I might say, here's what you need to do. Let's write down some of these questions, or better yet, I'll send you an email. These are great questions for your attorney. Why don't you ask the attorney what they have to say? And then when I send it to them, before they get it, I've already sent a different email to the attorney explaining what the heck's going on so they're not blindsided, and saying, expect these questions to come from your client because there's some confusion here and let me know if I can help. So let me tell you, if you're not in good with the attorney, you're done. Okay. You need to make sure that whatever attorney's handling either the trust or the probate, you got to make sure they understand that you're on their side. You're letting them do the legal. You'll do the real estate. You'll give them advice. Sometimes they don't know what they don't know, and you need to nudge them and tell them. But once they realize you're competent and have it together, boom, now you're good. They'll pay attention to you. You take care of the client. They take care of the legal stuff.
All right, Lisa Knight of Chicago Title. A similar question. What coordination do you need from the Realtor, attorney, and CPA during escrow?
Well, as I said before, the realtor is going to let us know the situation. So then we request those documents up front. We send them off for review. In regards to a CPA, buyers and sellers always ask about tax questions. We cannot answer tax questions. So right off the bat, we say, talk to your CPA, talk to your accountant for those questions. But also in a trust or a probate, you're going to need a tax ID number. And that's something that your CPA can help you with. So that's really important. It's always good to get that done right away. I'm still waiting for one for an escrow I just closed. Sometimes it takes a while, or
Yeah,
maybe if you're doing it yourself, you can get confused because if you're Googling it, you might get the wrong website. You might get frauded into giving somebody your money trying to get a tax ID number. You have to go through the IRS.
And once they get a tax ID number, do they have to open a bank account? And does that bank account have to be in the same name as the trust?
Yes, they do. So you'll
Why is that?
so we can't pay anybody other than who is on title.
Okay.
If you're on title in your trust, even if you're the trustee of your own trust, we still have to pay the name of the trust. But that's different. If you're still alive, you just use your social security number for your trust account at the bank.
We only work with dead people, you know.
Yeah. So if you're deceased, then you need that tax ID number right away. So my advice is to get the tax ID number right away because you're going to need to get that bank account opened.
And you remember I mentioned that this little girl that was 9 was the beneficiary of the entire estate? During the course of the transaction with the attorneys, the probate attorney, the litigator that I was working with contacted a probate attorney who sets up conservatorships for minor children. And I've done work with both of these attorneys. So when we closed escrow, where did the money go?
To the conservatorship.
Exactly. So that's because if you're 9, you don't have a bank account. And even if you did, you can't have the money. Okay.
We just need a lot of patience and understanding from the realtors and the attorneys. We just want to make sure we're getting it. We want to close your escrow. We want to make sure we have everything clear title. It's all about working together and communication. We talk a lot and I want to talk to you. So we make sure we're good.
And if she doesn't get the documentation she needs from the attorney, she calls me and lets me know, you or Arlena,
Yeah.
and just say, hey, what the heck's going on? Because we chat, right? And I'll say, I'll take care of it. Don't worry about it. And I'll text the attorney. I'll say, listen, we're all ready to close. You're the only thing holding the transaction up. They don't like that. What? What do you need? What? And of course, they immediately blame their paralegal.
Well,
We'll take care. And then magically, the documents appear same day.
Rick, what's your best advice when you've had hundreds of these transactions? Every transaction's different. When you go to a home, how do you decide, do we empty the house and have full inspections and maybe a little cleanup or deferred maintenance, or we just empty it? Or do you always have inspections from sewer line to chimney? What do you do?
Yeah, typically, a lot of the times, mom and dad or grandma and grandpa's stuff is still in the house. So I have an excellent relationship with a lot of estate liquidation companies. All right. Because typically the heirs don't want the furniture. In fact, they don't want anything. And you're typically not going to sell the house in that condition because eventually it has to go anyway, right? All has to go.
Mhm.
The buyers typically don't want to buy the furniture. It's not like you're buying, an Incline Village property that you're going to rent out and all the furniture transfers with the sale because they don't want it either. So you need to work with the heirs on what's going on. And that's usually a 2-step approach. There's stuff in there that has personal, sentimental, or actual value that the heirs or beneficiaries may want to deal with. So they go in first, get everything out. When I tell them this, I said, you guys go in and get everything out you guys need and let me know when that's done. And then we'll send in the estate liquidation company. They'll do an inventory and then they can get everything out. They present them a proposal. All right. The heirs are typically not interested in emptying the house for many reasons. Too emotional, they
Mhm.
don't live in the area, they don't want to have anything to do with it, et cetera, et cetera. And so if you're going to get into this business as an agent, you need to have these resources to offer your clients, and they need to be trustworthy. Number one. Number two, they need to be trustworthy. And number three, you need to be able to trust them. Are you getting the gist here? Because they're dealing with everything, all the personal property that family owned. So that's how that works. So the answer to the question is, once it's vacated, then we make a plan of action. And yes, we get every single inspection done in advance.
Rick, one of the mistakes that realtors make is they don't inform the clients they need to get this tax ID number and open a bank account. Can you think of any other mistakes that are common? Perhaps maybe a first time transaction for a realtor.
That's the typical one, but Lisa usually tells, she's,
It depends on how you hold title. So that's why it's so important to get that prelim going right away when you get the listing. And then we can tell you exactly what's going to be needed. And of course, let us know if the owner's alive or deceased. But any but
no, she knows it all.
But escrow will call the sellers and the trustees, will call them to let them know. So the tax ID number and the bank account, I don't know if they're gonna, Rick would tell them that up front. Because that's kind of more my process as we go along, as we get going on everything. But the tax ID number, yeah, that's so important. We want to try to inform them as soon as possible. That's what you're gonna need. And most of the time, people should have a bank account in the name of the trust. So probably 50% of sellers that are in a trust don't have a bank account in the name of the trust. And we are required to send the money to an account in the name of the trust when we close. So you'll have to get one open. And it's easy. It really is. Even if you're deceased, it's easy.
Right. But that's only if you're deceased. If all my properties are in a trust, if I sell a home, one of my properties, you don't have to send it to my trust account.
I do. I do have to send to your trust account now. Yeah.
That's recent.
Mhm.
That's right.
Mhm. Back in the day, we could get away with it and just do a little comma trustees, but now we have to send it to your trust.
Well, I don't sell any
Okay.
properties, I just buy them.
Ready for your question?
Yes, we are running early. We have plenty of time. We want to thank
That's because the attorney didn't show up. They're long-winded.
or the CPA, Janet, PNC Bank, thank you for lunch.
Yeah.
Speaking of associations, Gov Hutchinson has been traveling the state of California since the 80s, talking to associations. We have 58 counties, and I think we have 38 associations, 38. And he says Jody's the best.
Yeah.
Right? And then she's got a super duper web page with all these recorded webinars. And I think MLS has the same on their YouTube channel and all these wonderful reports that you could send to past, present, and future clients, especially heirs out of town. Very impressive. You have the county every quarter and different varieties for all the different types of visual learners or engineers. And then we want to thank our two guests here. You're not,
Mr. Rick. He is
And-
the pro. He is the pro.
and he uses Chicago Title,
I'm his.
specifically Lisa Knight. All right, so let's open it up for questions. Let's start with someone that has a probate going on.
Quickly, okay,
Oh.
one of the mics if I can.
Sure.
And do Zoom questions.
Oh, okay.
Yeah.
Does anyone have a probate or successor trustee representing a successor trustee?
I've got a complicated one. We aren't in contract yet because it's going through probate. Parents had a trust. Father died, mother died, two sons inherited per the trust. They never transferred any title.
Oh, that's a really good question. Well, they don't have to.
One of the brothers has passed. Okay. So now it's back as probate because they didn't have a trust. Parents had a trust, they inherited. Trust doesn't impact them, they never changed the title. So I'm going through probate.
Oh, so when they died, the property was not in the trust.
Was the original property was in the trust,
Okay,
both parents are now dead.
when the parents died.
But the two beneficiaries.
Beneficiaries got
Right.
the property. One of them died. He had nothing.
Yeah. I, d-
May I have a suggestion? So remember, we have the legal hotline at CAR, right? Okay. And then the California government has a wonderful website and phone number that I have in my pocket here for taxes. But, and of course, the wonderful MLS has a compliance. But if you have a specific question about your transaction, that we could lose some time on that. But if you have how to common mistakes in a probate or estate sale, so everybody can learn, let's do that. Okay, Jamie, I recognize you from all the Zoom meetings.
Crazy all the place, but
Hi, Nick.
I just do basic. That is, okay, that
Should he
is,
have a mic?
the home is, there's a trust out there. You mentioned
want me to-
that trust don't need to be recorded, but they're notarized. Okay, the only people that are gonna know about a trust is, title or something like that.
the family.
So, but a home.
Jaime, can you repeat the question?
Okay. Well, yeah, so I haven't
Starting
gotten
it
there
up.
yet. I really haven't gotten there yet.
What-
Okay, so, there's a home that is owned by an owner, an owner, and the trust happens to have that property in the trust, but nobody knows about it until the heirs or whoever the executor knows about it, right? But the county doesn't know about it because it was never really put in the trust at the county. So, if that person, if the owner of that property dies, how are the county or how are they going to avoid probate? Because no one knows that the property is in the trust.
That's a,
Well, you can't, if it's not recorded in the trust, then it's not in the trust. So if you have a trust, you still have to go through probate because the property is not vested in the trust.
Right.
So you go through probate and you have to get what's called a Hegstead order. So it's still, because you have to have your property recorded in the county in the name of the trust. If you pass away and it's not recorded in your trust, yes, you have a trust, but it's not recorded. You have to go through probate to get a Hegstead order.
Right, my
to get-
next question was, follow ahead, take time. People get homes refinanced all the time, refinance. Though during that refinance, the home never gets put back into the trust.
It's unfortunate.
So what happens is that you're gonna end up going to probate, right?
If you're not in the trust when you pass away, you have to go through probate to get a Hegstead order.
Nobody can
So-
go to court, say, hey, I have the trust. Look,
No.
this home's
so
a trust.
I think,
Oh, sorry, the Hegstead order puts the property in the trust.
Yeah.
So that's why you have to get an order.
Again, later, after the fact, the Hegstead thing. Okay, look.
Easy to find out if a property's in a trust. Preliminary title report. The owner will not be the names of the owners. The owner will be the name of the trust, period. If it's not in there, then it's not in a trust. If they had a trust and they refinanced and they forgot to put it back in, or if they had a trust and forgot to record it, I've had an attorney do that on their own home. We're closing it. Then you go to the probate court, the attorney goes in, it's not probated, but the probate court can issue the Hegstead order, which then takes the property and says, look, everybody knows this is what they intended. We're putting it back in the trust. It's in the trust. It's then recorded. A new preliminary title report is issued. Now the property's in the trust and you proceed accordingly. No probate necessary. That's what the Hegstead order does.
Right, time period, what's the time frame on that?
Probate to get the order.
What is the time frame on that? Just curious.
You don't know.
It's just, it's a 30-day minimum. Hegstead. Oh, no, there's no A in it. I don't think.
Hegstead, Hegg.
Anyway,
Yeah.
any of
We don't know.
it'll be several $1,000s to get that done, but it'll be peanuts compared to the probate costs that you would have paid.
Okay, we have
I got a
question.
Zoom
Oh,
question.
we have a
And then I'll go-
Zoom?
Yep, I got lots on Zoom, actually.
Okay,
But
let's do
bounce
it.
back and forth.
Okay, short ones first.
Yep. If a probate is taking 4 years and the lawyer is not responding, who should the executor contact to finalize the probate? Since the heirs have all signed the waiver of account and the lawyer said that was the last step.
Yeah, I'd want to know how many days have occurred since the last step, and then I'd contact an estate's attorney that is a litigator and get them involved to get someone to move their rear end.
Okay,
This is not shocking, by the way.
Hi, I have a situation, not me, but someone I know, where there is a conflict between the prenup agreement and the trust. And she's the executor. It's not going through probate, but I'm just wondering, how do we find out what takes precedence?
as an attorney.
Okay, that is why you pay attorneys, and
Yeah.
my advice would be hire a really, really good one if you want to win.
That was.
There is a difference.
You want me to walk it around?
Thank you.
Okay, we're gonna do another Zoom question,
Gonna do one more Zoom and I'll come over, Lily.
then the man with a hat.
Okay.
I know you do.
In case we're busy, is it okay to just type up a living will and the living trust and have them notarized by 2 witnesses?
I do know, I have seen buyers do that because they want to put their property in the trust. They go online, but I mean, we would never advise that. We would never say that's a good idea. Go for it. That's not what we do.
Right here.
But you still would have to put the real property in that name of that trust. If they provided that information to me, I would.
Here's the attorney answer to that question. That's great. I will make a small fortune and put my children through college. That's why you pay a trust and estates specialist to do these things. Mistakes can be made. I mean, look at all we've talked about since we've been here today about all the things that go wrong. And these are with licensed attorneys who've drafted concrete trusts that are actually really good. And just the people involved have made them go so sideways that we have to talk about them, right? Imagine drafting your own trust and recording your property in it and then having your heirs deal with that later. So, well, Dad drafted it. It should be fine, right? He knew what he was doing. Heaven forbid any laws change since Dad drafted the trust, et cetera, et cetera. So that, whoever asked that question on Zoom, do so at your own peril.
I think this question is to Rick. I have a listings which I signed. It was almost 9 months. And the difficulty is right now, there's 2 administrators being, they have the letters, testament, and it was assigned in these properties. And those 2 administrators, and one actually is the husband of deceased. He is currently living in the properties, and the other one is the sisters of deceased. And both of them, they are very, uncooperative to each other. The sister, who is another part of the administrators, want to sell the property ASAP and be fighting with the husband for over 9 months. But the husband is living in the properties, doesn't want to do anything. The house is like a hoarder's, junks, full of everywhere. So he's refusing to be cleaned up. The sister, the other administrators, and trying to get everybody's, coming in to clean, but it's been refused. So they actually consulted with another attorney, which is a litigation attorney, and asking what's going on. But litigation attorneys right now look, but the property still sits there, and there's no progress. The probate attorneys is kind of doing nothing at this point, and the probate attorney was hired by the husband, deceased. So the blame by the sister was saying, that attorney is having, the biased, whatever is very biased. So that's the situations I'm hiding now.
There's two things you should know. Number one, I hope you didn't sign a 9-month listing. Well, you said it was listed for 9 months. Probate listings are limited by law to 90 days. Okay, just so you know that. If you have a 9-month listing, get rid of it. You can have a 90-day listing and you can extend it or you can renew it. But you cannot have a probate listing longer than 90 days by law. Second item, nothing will happen until the individual living in the property determines that he's going to move. Whether he's forced out or whether he decides he needs to go or whatever, until he moves, nothing will happen in this transaction. That's why a litigator is involved, because now they're going to try to force an eviction. And that's going to be very difficult and very costly. I could see, easily 6-figure attorney's fees.
I think you guys answered the question, but the question that was in Zoom was, do the living trusts have to be done by a legal attorney, or the courts just accept it if you write it on a napkin?
Courts don't usually have anything to do with a living trust unless there's a dispute between the parties and it goes to court in form of litigation. In terms of, can you just draft a living trust? There are things on the internet you can pull down and they're probably legal. I don't know. But if someone actually did that and there were absolutely zero problems and the laws didn't change at all between when the trust was drafted and the property was actually recorded into the trust, and all these things are things that go wrong even when attorneys are involved. But if all of those things happen, could it be possible that someone could do that and survive the transaction in the end, saving their 3 or 4 or 5,000? It's possible. It does have to be notarized, and then you'd have to you have to record the property into the trust. So whatever you named the trust, that needs to be how the property is titled.
Okay, far back.
Hi, does having a sole beneficiary on a property, or if there's no trust, does that expedite the probate process at all or simplify it?
It can simplify it to the degree that they're not likely to argue with other people over the disposition of the decedent's belongings or property.
So you would still recommend a homeowner with a sole beneficiary to get a trust?
Only if they want to save thousands and thousands of dollars. Trusts are the way to go because you can put everything in it. You can put IRAs in it. You can put KIOs in it. You can put property in it. You can, I have a baseball. Where's KB? I have a baseball signed by the 1962 World Series Giants teams. Rachel's getting that. Why? Because she asked for it, and Rebecca could care less about baseball. That's in the trust.
So you were starting to talk about survivor, if you have joint tenants with right of survivorship, can you kind of go into that? And what if you only have a will and you don't have a trust, and what's the impact?
So when you hold title as community property with right of survivorship, so a husband and wife can only be married for that. If one of them passes away, it transfers to the surviving spouse. If both of them pass away, it will need to go through probate. With joint tenancy, it's kind of the same thing. So I could be in title with Rick. We don't have to be married. But we're joint tenants. If I pass away, it would go to Rick, vice versa. But if we
How did that vest it?
they won't, because I'm joint tenants with Rick. So it automatically will go to Rick. Same, if he passes away, it goes to me. Now, if we're not married and we're just tenants in common and I pass away, if I'm not in my trust, so you could be in a trust as tenants in common. You cannot be joint tenants in a trust. Joint tenancy is for individuals. So if I was just tenants in common in my individual self and I was to pass away, it doesn't go to Rick, it'll have to go through probate. Just my half, because Rick's half is fine because he's alive.
My miserable Rick.
Yeah. So.
I have a Lee McKim.
I have a question for everyone here. Since most boomers are aging out, And there's going to be a lot of this in future.
Can you go louder for the Zoom?
Okay, because of the aging of the boomer cohort generation that owns a lot of real estate here in the Valley and other areas, is it possible to promulgate a form that talks about the seller side, the listing side, to assist everybody in the real estate community? When they start with the trust, they have a blueprint to kind of step down and notify title, et cetera. Can we promulgate a form to assist everybody that's beyond this particular meeting, that's going to be facing trust issues or non-trust issues and will issues? Because I think if we had at least a menu to start, like very
Right.
first, who do we contact? What should be said? And how do we protect ourselves first and then our clients?
That sounds wonderful. I'm in.
That's a good idea, except the form will never cover all circumstances.
Blueprint.
Yeah, I mean, that's what's on my website. You know, I mean, people go there and they look, well, does he have a clue? It's like, oh, that's how he does things. So that's not a bad idea, because it's certain items are, yeah, let's check the boxes and make sure we've got things going. You know, for example, do we have a copy of the trust? Yes, great. Is there an attorney involved? Yes. What's the contact information? Is the property recorded into the trust? Oh, good. We got the pre. Yes, it is. You know, does the trustee or the estate have a bank account in the exact name of the trust? Yes. Does it match what's on the prelim? Yes. Oh, okay, good. So those are the kind of things that you can do that would be good to know. And if a property's in a trust like that.
That's one follow-up question. If you have this laid out on your website,
It's narrative.
but could you possibly come back and present that to the group? I don't want to put you on the spot.
Did you not tell them that I don't like to work? It's snow will be falling shortly. I have a home up there. I ski during the winter. Yeah. That's not a bad idea. I use a form whenever I go and interview a prospective.
That's what.
Yeah.
A lot of listing agents do.
Yeah, I have that myself, and but it's intuitive to me, so I don't have every question on there. I just have, yeah. That's something to consider.
Could you talk about,
Grace,
A list of what is, we know what we need. I don't know in regard to, we have a list of what is needed for probate, the trust.
okay, could you talk about securing probate listings? What usually goes into this, how probate listings typically happen? And to be more specific, there are a bunch of data sources where you can get a list of new probates that get started. You can get the property addresses. You can get some contact information. Let's say you're mailing them a letter. What would you say in this letter?
So let's go to the initial thought, which is, if you're going to consider going into marketing yourself to attract probate listings, the first thing I would do is either take CPRES through a third party, that's a certified probate real estate specialist, or CAR has a certified probate program.
that's this one.
Okay.
right?
And yeah, and I would do that before I did anything regarding that. Attorneys know if you don't know anything. There was a woman in our office that contacted me too late. So we'll have this probate listing coming up. She had visited with this person 6 or 7 times, an elderly person. And when the rubber met the road, the attorney said, don't list with that person. They don't know anything about probates. I want you to list with an expert. So when she got me involved, it was too late. And I knew the attorney. I didn't know the attorney, but my other attorneys knew this person very well. So it would have been a slam dunk, except it didn't happen. That's what happens. So get to know what's going on first. Okay. Then if you try to do some business with those people, when I started doing this back in the early 1990s, we didn't have the internet, and I would basically go down to the records basement at the county and pull up probate records that had real estate in them and basically mail off letters and packages to the attorney and to the either administrator or executor, depending on who was confirmed. And I was listing property that way. That helped. And then I realized, wow, that's one off. Then I realized, wow, some of these attorneys' names are coming up fairly frequently. Why don't I just try to reach them instead? And so that's what I did. But that's been a long time ago. I don't even remember I don't remember how it happened, Dimitri. No, it's a relationship just like anything else. And so that's the best way. You prove yourself, you demonstrate your knowledge, you let them know you're available to do whatever they need, because oftentimes they just need to know, hey, how's this title? What's going on? I need a deed for this property. It's got to have the legal description. It's got to have this, whatever. And pretty soon you start working with them, and eventually you'll earn enough respect from them that they'll say, I've got this one coming up. Why don't you go out there? That's how that works. That's how it worked for me. I would say that the attorneys have excessive influence over how the property is listed and who lists it. Because if they're looking at 3 or 4 different realtors and the attorney says, no, this is the person you want to do business with, and you're the seller and you've never sold a house before, and your attorney you trust, and you just met the other 3 realtors, you're going to pretty much do what the attorney says. Well, they're 2 different issues. I work with a lot of professional fiduciaries. They're great. A fiduciary is one that is empowered by the court to act on behalf of others. All right. And I work with 5 or 6 of them right now. Some of them, I've sold houses for at least 7 or 8 of them. And it's the same thing. Relationship. What do they need? Deliver the goods. Do everything right. And you're going to get some business from them. There are meetings for for estate planning specialist attorneys. That means they handle probates and estate and trusts. There's Silicon Valley estate planning attorneys. There's a Peninsula group. Same thing with the fiduciaries. They have group meetings and things like that. But I would really know my stuff before I wandered in there and, started to pitch my wares. In fact, the only time I've ever attended those types of meetings was when I was brought as a guest by either an attorney or a fiduciary and introduced around. I didn't want to go on my own.
How does probate work with conservatorship?
Well, conservatorships are a little. Conservatorship basically is, again, someone acting on behalf of someone else, and they're not that common, but you run across them. I've done 5 or 6 of them over the years. They're usually handled by the probate court, and it's basically instead of an administrator or somebody there, oftentimes they have a conservator acting on behalf. It's typical when they act on behalf of a minor, okay? Or they'll act on behalf of someone that's incapacitated or someone that is fine and okay, but not that great. Right. And then it's basically handled in the probate court, and it's basically the same. You're following instructions, you're doing things the right way. It's just a different set of rules that you're playing by, although you're still doing all the right things to make sure that the house is sold and the most money goes to the person they say should get it. You don't touch it, but they're telling you where it goes. I had a conservatorship a long time ago, and the people were from out of state, and he was somewhat incapacitated, but it was a conservatorship, and they had a conservator handle the proceeds from the transaction until that person either reached the point of capacity or a certain age. And I wasn't sure because you don't see a lot of that side of it once it's a conservatorship. Same thing with a guardianship. The one we did, I knew what was going on. I knew both attorneys, but I also knew that was Zahid would handled that one. And all the funds went to him and he handled it, and that's that. Where's the money? He's got it. Where did he do? He invested it. Where is it? It's in a licensed trust account that's being operated by such and such and in following certain parameters. So when that child becomes of age, there'll be a whole lot more money in there than there was when they first started. So it's a big time trust thing. A trust as in not a trust sale, but these people that are conservators and guardians and the county, they really, really, really have to play by some heavy rules. And they're very conservative with them. Money markets, not stocks, things like that.
So putting a home into a trust and having it notarized and having it recorded at the county doesn't change ownership, so it won't change the assessment of the home, right?
As long as it's the same owners in your individual self, same owners that already own the home, and then you're just transferring it to your trust, that is correct.
Is
Yeah, so you have to fill out the appropriate paperwork with the county. And if you are getting a trust, that trust attorney should be doing the deed for you to put the property in the trust.
okay. Is there a situation where it could trigger an assessment?
If you are tenants in common and you take title, one individual, if you have more than, so if you go into title, let's say 50-50, okay? And then now you want to go into your trust and you want 75%, then the county's going to reassess you on the 25% that's going to the person in the trust. So it just varies in regards to who's already on title and how you're going to deed out and who's coming in. So yeah, their properties will be reassessed, but if you're already the owner of the property and you're just going into your own trust, there's no reassessment. And no transfer tax.
There, so got your hand up. I promise I'm paying attention.
Rick, you have mentioned numerous times the word a good attorney. I think it should be a great attorney. I had one where he knew one of the beneficiaries was on disability, couldn't have anything in his own name. We were trying to work out how to get him into a property without it being in his own name. And, it was very complicated. Come to find out, he had done so many addendums to the original trust, it made no sense. The the trustees asked me to go in with them to talk to the attorney, which of course, he's not gonna let me in. He finally did let me in. And as calm and as easygoing as I am, if anybody knows me, they're gonna go into hysterical. After about 15 minutes of trying to explain this to him, and we're at this big conference table, I finally just slammed my hands on the desk, stood up. I thought he was gonna slide his chair through the window because I said, will you please listen to what I'm saying? Having a good attorney that hears what you're saying, not just listens to you, hears what you're saying is so important. We lost a transaction because of that. But anyway, I just wanted to make that comment because it is so, when he wouldn't communicate with me, I knew there was a problem.
Okay, while you're passing that, I just want to make a point. So, some attorneys make mistakes, and that causes a problem with the escrow office and the escrow, right? And the attorney might call up and start chewing you out, and then that's when you bump it upstairs to the title officer. And
You bump it upstairs a lot.
okay, there you go.
I had my clients go to my trust attorney and he had to rewrite the whole thing. To me,
Okay.
so it would show us.
James?
James?
And thank you for the discussion, most informative. Mine's only a suggestion. CAR has a probate course. And for fundamentals and just learning how this goes and what Lee was saying earlier about forms, the best thing to do is start from that basis and then work from there. Now, there's a lot of variables to these things and Rick has already pointed them out to us. And I would highly recommend and suggest start with something basic and the CAR probate would be the best way to go.
So it sounds like I will be contacting Nate
Yeah.
at NAR booking a probate class. Also, I just want to reiterate that an attorney that listens to you and lets you have your moment while and they're silent and let you have that moment, because working with these things is very frustrating. And having them say to you, I hear you, and then moving on is super helpful. So if you've got an attorney that's going to let you have that moment of frustration and listen to you, that's a difference.
So firstly, I want to thank you both for sharing your incredible and valuable wealth of knowledge, being in the trenches and sharing it, gems of wisdom and otherwise. Thank you. So my question is regarding that adult child who might be afflicted with a spine disorder or perhaps lacking one, who's staying at the property and just, you know what I'm talking about, right? I've seen some of my short sales and they just don't want to move out the house. They don't have the resource. They don't have the capacity or intent to want to move. I imagine it's a lot of sticking point in there in getting traction towards probate court. Is there something in the way you can hire, perhaps if you can find somebody to assist them, maybe perhaps a neutral party that they're amenable to work with, not a sibling who they're fighting against with everybody, let's say we find personal assistant? Is that something that the framework of the probate might be able to compensate in the future, or how does that get worked out? Because there has to be some sort of trash. You can't just sit, nothing happen. You understand what I'm saying? There has to be some sort of movement towards.
Right. So I want to make sure I understand this right. There's a person in the property, an adult legally, but they're incapacitated in some way, shape, or form. Sounds like physically. And so staying moving is not an option for that person. So at least not on their own. So in order to get them out, because let's face it, if the property needs to be sold, it's highly unlikely a buyer is going to buy the property and move in with that person. That's not going to happen. So they have to go, right? And so then it becomes incumbent upon the family to figure this out. The attorneys can be of some help. The realtor can be of some help. It depends. The best case scenario for this is if the estate actually has additional funds besides just the equity in the property to deal with this particular scenario. And then if it can be handled kindly, considerately, with empathy, and get that person safely and healthily to a different location where they can live for a little while or maybe thrive or something, then that's the right way to handle it. But those are very sticky and difficult situations, and you don't necessarily want the court to get involved with that, because a court would then at some point in time, their options are so limited. They're talking about a conservatorship. In other words, someone with power over that individual. And then basically now you've got, the court says, well, then you guys can't figure it out. That person's going to decide. And so you probably want to avoid that. And that's the best I can offer. Those are extremely difficult family and personal situations, and they always make for the hardest types of transactions because, and as a real estate broker, I'm saying we do need to get them out before we can sell the house, because we do have to transfer title, and the buyer is not buying, a house and a roommate. So that's how it is. Now, I'll help any way I can, but this is really on the family to come up with some ideas. At that point, there may be, and it depends, because there may be too much money involved. But if there's a dollars issue, that may be that the city or county or possibly the state, I don't know. But you're talking about a circumstance that I have yet to see. I haven't dealt with a transaction like that. I've had to get people out of properties before, and some of them would have been considered absolutely not 100% there, but we were able to manage things, and I would sit down with the trustees and the attorney and say, what are our options? Who's got some money? Where can we do this? What if we have money? What are the options? Where could they go? How could we handle this? That type of thing. And you're kind of winging it at that point. There is no checkbox for that one.
Thanks, Rick. I'm Himalini from Legacy Real Estate. So you are doing a lot of work as a listing agent than normal listing. how much do you charge for the seller?
Well, commissions in the state of California, as you know, are negotiable.
Yeah, we can't,
But
So,
and we can't talk about it in a group
Yeah.
meeting, right?
yeah, generally speaking, I do a pretty good job. And I get paid a lot.
He has a house in his,
That's why you get to
And
go
they-
to Incline and go skiing for 3 months out of the year. Good job, everybody. I wanted to make two comments. This is an excellent consumer service. I encourage you to do it, to get a very powerful, knowledgeable team and run these type of programs through your brokerage if you can. We do a basic 101 estate planning class for real estate. We do a basic trust, trust documents forms and selecting your trustee, all those kind of classes. We have a class for trustees that say, I'm a trustee, now what? So that they understand what the responsibilities are in a real estate transaction if they are the trustee. So it's a great driver of community service. I really encourage you to do it. Takes a lot of time, a lot of effort. You've got to study a lot. You've got to have the right connections and the right resources, but it is very beneficial to the public. I was very fortunate to be invited to probably the very best estate planning and transfer of real estate, two airs or seminar last week. Dimitri was there also. It was given by Hogue Fenton at 55 Market Street in downtown San Jose, one of the supreme real estate. They have every division in that law firm, but they have a very advanced tax planning and estate planning service. I encourage you, if you want to learn more, if you have the opportunity, get to one of their seminars. Absolute best in the business. You can finance, there's ways to finance the distribution of assets to heirs in the future through, insurance policies. I mean, there's just so many things they can do. And then they have very advanced divisions for stocks and crypto and everything. I mean, just
Okay.
everything out there is available. You just got to find the right resources.
Mr. McKim.
Since we're all in this together.
Wanna check Zoom?
So circumstance.
Yeah.
I would ask everybody that has anything to do with a title officer and an escrow officer to also prepare some type of blueprint so we could walk our way through so we can determine what the issues are. And I was wondering if they could do a joint presentation. One side is for the listing side. The other side would be what does escrow expect? Because between the two of them is probably most of the pitfalls. So if you guys could prepare just a general guideline about what you expect in a pre-listing package before this property is actually moved forward, I think that would help. But it's just a suggestion. You could talk among yourself, but Jody, if you could talk this up, that'd be great.
A lot of stuff that we used to do classes.
With
Yeah,
a form that they can take home and say, okay, these are the top 5 questions I've got to ask
yes.
before we take the listing. These are the 6 top questions, just a general guideline that sensitizes everybody to what is the best practice moving forward. I
Good
think that would
idea.
be a benefit for everyone.
Okay. Any questions?
Do you want to go through questions?
If you have any on Zoom?
There was one on Zoom. I can half answer this, but they want to know if attorneys get paid at the end of
Oh,
out of escrow. I can say no.
Typically, attorneys are not a party to the escrow. I have had attorneys put bills in escrow on certain transactions. One in particular, which was a probate involving 2 properties and 2 brothers that was whacked out. And, and the attorney made an incredible amount of money on the transaction and earned every penny of it because the one brother should have gone to jail is what he should have done, but he didn't. He got proceeds instead, and it was all because of his attorney. So let's leave it at that. Generally speaking, though, it's a pay-as-you-go kind of thing. And by the way, if you're in a trust and you hire a trust attorney and you're dealing with all this, guess who's writing the checks? the trust. Exactly. Yeah.
Rick, this is for you. Just real quick, I've heard before when this situation starts that you need to get an appraisal on the home. Is that one of the first things you do?
No, but I'll tell you why you might be wanting to know about this. The IRS has a section that allows a spouse that dies, the remaining spouse, to get a step up in basis for the purposes of capital gains. The same applies when the succeeding spouse dies and a property is now in the trust and it's like, oh, the kids got it. Well, what's the value of the property at time of death? There's a couple of rules of thumb there, okay? Generally speaking, and there's a paper on this that is not an IRS rule, but they wrote a paper, a letter, I think they call it. If the property is sold within 6 months of time of death, they consider the sales price the value of the property at time of death. If it's beyond 6 months, an appraisal is the very best way to do that. And it doesn't matter. I mean, I'm doing one Saturday for the for a woman whose husband died June 9th, 2024. So it's a value in arrears. I've done them for people 10, 20, 30, 40 years past. Okay. I don't do them. The appraiser does them. And getting an appraiser that understands why they are going to the property and what they need to do is critical at that point. I have one in case you need one. She is absolutely top notch. But yes, the reason that they ask for an appraisal is you can use a broker price opinion. Here's the problem. The only time you're going to need it is if you're audited. And they say, how come you didn't pay capital gains on the sale of that $4 million residence? I say, well, it's real simple. My wife passed away and it was worth 4 million when she died. And so I sold it and I moved on. That person should really have an appraisal if they're being audited. A broker price opinion generally could work, but at that point, why would you take the chance? Does that answer your question? Well, yeah, you do need it. You need it every time that's on title passes away. Here's why. Suppose my wife dies, heaven forbid, right? And I want to get an appraisal done at the time of death because that's my new basis in the property. So now it's done. Okay. We've owned this. We have one property that we've owned for 40, how old's Rebecca? 42 years. Suffice to say, it was really inexpensive when we bought it. Okay. But now it's worth a lot of money. So that's a stepped up basis. I want that. And I want to know what it is. When I pass, my kids are going to do the same thing. That would mean that, oh, well, what are we going to do with dad's house? Mom died 20 years ago. Now dad died. Now we've got to get it. We've got to get it done again, unless it's going to go on the market right away and probably sell within the first 6 months, in which case it's not critical because the IRS has issued a letter saying, yeah, that works for us. Now, always talk to the person who's going to be doing the tax return. Don't take my advice. This is advice. This is what has happened generally. Get advice from the accountant that's handling that particular return. Because in a trust, guess what? The trust fills out tax returns too. That's why you have a tax ID number. Okay? That's what it's important for.
I have a quick question. Lisa, so you are an escrow officer, but you have title insurance. So every transaction has an escrow officer and a title officer. Can you speak about the role of a title officer, especially in these transactions?
So they review everything. So I'm the first line. I'm your main contact. Anything on the prelim, anything we need to get cleaned up regarding deceased owners, liens, construction. I mean, there's lots of stuff. Our title officers are behind the scene working with us to get everything kind of cleaned up so we can issue that clear title to the buyer. And then we have underwriting. So it's me, escrow, then I have a title, and then I have underwriting. So when title can't do what I need them to do, or we need underwriting approval, we go to underwriting. But we just have levels, as Rick knows, but we're always the communicator, escrow. So anything you guys need, the clients need, we're the first line. And the title officers, they're our backup. They review everything. They review LLC operating agreements. They review all the trusts.
Don't you have attorneys on staff as well?
So we do have corporate attorneys. We like to call them the chief underwriter. And sometimes we'll throw out the word attorney because it looks good, as Rick knows. You know, sometimes we have to use that language, but we have amazing, amazing underwriters that are working for us all so we can get that transaction closed.
And she's not kidding. I have had numerous times over the course of the last 25 or 30 years working with Chicago Title where we've had a title issue that seemed insurmountable. And I've done conference calls with the attorneys handling the trust or the probate, along with the attorneys that are their chief underwriters. And we all get together on the phone, a conference call, and we talk it through. And most of the time we've been able to figure out a way to get things done. Sometimes it's not pretty, but it's like, if you do these things, we will then insure the title. It's most title companies aren't willing to necessarily go, that far to help us out. But my experience with Chicago Title has been exemplary, and that has been a bonus for me. I'll tell you, I can think of at least 3 transactions that I would not have closed, and one of them was not small. Had it not been for contacts with the underwriting department and 2 or 3 other attorneys on our end, all having it out and saying, how can we fix this? And then finding a way to fix it, and then it closed. It's like, wow, you'd think that would be kind of commonplace, but it's not in the title business, except with Chicago Title.